This podcast is brought to you by the IIEA, sharing ideas, shaping policy.
My name is Heather Burke and I'm a researcher here at the Institute of International and European Affairs. This podcast is part of the IIEA's Future Proofing Europe project, which is kindly supported by the Department of Foreign Affairs. Today, I'm delighted to be joined on the podcast by Judge Eugene Regan, who is the Irish judge on the European Court of Justice. I'm really looking forward to talking to you, Judge, for the next 25 minutes or so on the rule of law in Europe and the role of the Court of Justice in safeguarding this fundamental principle. I hope also to talk with you about the future of the EU in terms of enlargement and the rise of AI, and what these might mean when we speak about protecting the rule of law. So thank you so much, Judge Regan, for joining me today. And by way of quick background, you were first appointed as a judge at the Court of Justice in Luxembourg in 2015 and were re-elected for a second term in 2021. You were also the first Irish judge to be elected by your peers to serve as the president of the chamber, a distinguished position which you held for the past 6 years. I wonder, to begin, if you could first introduce the Court of Justice, its role as an EU institution, and what your responsibilities as a judge entail.
Yes, well, I suppose to begin, the court consists of 27 judges, one from each member state, where all our judgments, or practically all our judgments, are translated into all languages of the European Union, 23 in total. Also, our hearings are heard in the different languages, depending on where the questions and the case originates from. So that the idea is that EU law, which is part of national law, is fully understood and easily understood by legal experts, but also the general public, that it's through our press releases, the judgments are understood. That's the general idea. So the court is a court of interpretation. We have EU treaties, we have regulations, directives, and where there's an issue in a court of a member state, where there's a issue of interpretation and a dispute about interpretation, it falls to us as the ultimate arbiter in terms of interpretation of EU law. That's our principal work. We also, of course, have appeals from the General Court here, competition law matters, these type of intellectual property, etc. And also we deal with infringement proceedings, which are initiated by the Commission against member states for failure to comply with EU law, with a directive, properly implemented directive, or a blatant breach of EU law, which some of the infringements which come before us, we have to adjudicate and decide whether the Commission has a valid case in taking an action against a member state. That, in summary, is our mandate.
And I think looking at the role of the Court of Justice in safeguarding judicial independence and more generally then the rule of law, this has been seen as basically a truly revolutionary evolution in the role of the court by some scholars. And also the court in protecting rule of law is viewed as one of the most effective EU institutions in this regard. And so I wonder if you could explain what it is the court does to interpret the treaties in respect of the rule of law under Article 2 of the Treaty of the European Union. And if there's any case law that, in your opinion, exemplifies what the court has achieved and done to protect the rule of law.
Yeah, it's a good question. And I suppose I could start with a case concerning a lawyer here in Luxembourg, a British lawyer who applied to practice at the bar in Luxembourg. And there was a judgment, there was a ruling that he could not practice because language or whatever qualifications that were deemed to be applicable. That case came to us, and it's known as the Wilson case, where the court ruled that the panel who decided that case was not independent. And in that case, the court explained that independence is required from both internal issue, that's impartiality, and a court must be independent in terms of external pressures or influences, political or otherwise, that might apply. So in my view, the whole issue of defining the independence of judges and judiciary, which was, of course, an issue that has come to the fore, was well set out in this case of some years ago. But we had a second case, which again is fundamental importance, and that is concerning the Portuguese judges case that's generally referred to. And that was a reference from Portugal, where the court was asked, there was a general reduction in judges' pay in Portugal. And the question posed to us, was this not an interference with the independence of the judiciary? Now, this case had a resonance in Ireland because if you remember when public servant salaries were reduced, that was, and we had a referendum ultimately on judges' pay in Ireland. But the court ruled that since it wasn't targeted at judges specifically, it was not an interference with their judgments. But what was important about that case is we clarified that in respect of EU law, it depends on upholding EU law and the proper implementation of EU law, that you must have an independent judiciary in member states, because the European Court works with national courts to ensure together that EU law is applied. And if you don't have an independent judiciary, and if individuals cannot have what is referred to as an effective remedy before an independent court, and then there is a breach of a particular Article 19 of the treaty, which requires member states to have in place a system where individuals can uphold their EU law rights before national courts. And it was the clarification of that issue which then was very important subsequently. There was a third case, again emanating from Ireland, which was the issue of an extradition of a Polish person who was accused of certain crimes in Poland. And the High Court judge in question questioned our court as to whether that person could be assured of a fair trial in Poland, given that the European Commission and other bodies had suggested in reports that the rule of law was not being respected in Poland. The importance of that case cannot be underestimated, because it is that case which launched the debate and the political discussions on how to ensure that the rule of law in Poland was not undermined, and that there was no backsliding on the whole issue of the rule of law. Absolutely fundamental. So the court, I think, in clarifying these issues, has played a role in highlighting the fact that a member state is in breach of the treaty if it does not provide for an independent judiciary. In Poland, they attempted to reduce the age limit and to retire a host of judges, which was seen as an interference in their independence. And subsequently, the Commission took many infringement proceedings against Poland on foot of our judgments, with the clarification of our judgments. Also resulted, those infringement proceedings, in the blocking of EU funds to Poland, and ultimately to a resolution of that rule of law crisis. Now, it was facilitated by a change of government in Poland, but ultimately, I think the effect of the judgments, the actions of the Commission subsequent to those judgments, created the grounds for the change of position in Poland and a resolution of what was a fundamental crisis.
And I think it's interesting that the role of the Court of Justice in protecting the rule of law in national courts is also sometimes we have national governments, European governments, beginning to cast doubt on some of the judgments emanating from the Court of Justice itself. And this might sometimes feel as a judge in a court that this isn't something one can preempt or even react to. I was wondering, do you think that is true? Or do you think there are actions that the Court of Justice can take to remain as a trusted institution and to ensure that its legitimacy remains?
Well, the court's legitimacy is in upholding the treaties, upholding the values which are provided for in the treaties, in particular the Article 2 values of democracy, rule of law, fundamental rights. This is something that all member states have agreed. So where we take a judgment that is not to the liking of a particular member state, we are upholding what has been agreed against that member state who has failed in some material respect and infringed the commitments that have been entered into by all. So I think in terms of trust in the court, we have to do, we need the trust of all member states, those against whom we take an action and which must be complied with, but also all member states who, if we did not take appropriate action and uphold the treaties, uphold what has been agreed, then there would be a greater lack of trust in this court. I don't know if that answers your question, but I think it's an important consideration that in terms of challenging the court, we had one member state who challenged specific judgments of the court, and that is Poland. And they have reversed their position entirely on that. There's a case before the court which is in regard, it's an infringement action against Poland for not respecting our judgments. And Poland has accepted the validity of those infringement actions, that the judgments should have been and will be respected. So I think that is, I think, the answer to your question.
It absolutely
and
is.
And the proof is there, you know.
Yeah, it is clear that, you know, if a member state is questioning the court or rulings of the court, it first has agreed, you know, to be bound by the judgments of the court. I think also, even looking at maybe general populations in the EU who might be far removed from Luxembourg, who might not understand really what the court is doing at all times, do you think there are ways to connect people more closely with the work of the court, that there are ways to kind of inform the public as to what it is the court is doing on a day-to-day basis, or how it reaches its judgment?
Well, I think on the important cases, there are press releases issued clarifying our judgments in layman terms. Also, the most important judgments, which are dealt with by 15 judges in, we call it Grand Chamber cases, those hearings on those cases are now streamed. So people can have access without coming to Luxembourg as to how we conduct our business, what questions we ask the parties, how we behave towards the parties. Do we, you know, give a fair hearing to the different parties? I think that is fairly transparent. So I think it is basically doing our job in terms of producing coherent quality judgments which are readily understandable. And as I said earlier, all our judgments, or the vast majority, are translated into the languages of the individual member states. So they're readily available to a mass audience.
On the point of languages, actually, I am, looking forward to an EU that might have a potential 10 extra member states in the near or somewhat near future. How would the CJEU look in an enlarged EU where there are more languages, more judges? Do you think there would be need for institutional reforms in that case? What do you see for the future of the court?
Well, you'd see a larger court. I think the principle of one judge per member state would certainly prevail. But if you think about it, the court has gone, as Europe has, from a community of 6 to 27, originally 28, and it has had to adjust to these changes in terms of size, in terms of languages, and it has been able to do so quite seamlessly. Of course, there's an investment required, but the court conducts its business in a chamber of 15 judges, or a chamber of 5 judges, or a chamber of 3 judges. That would continue to be the case. So the fact that you would have more judges wouldn't necessarily create any issue there. But what's important about having one judge from each member state is that there's a greater likelihood that we have the input from all member states, from judges with the experience of their member state, and likewise in terms of explaining our judgments. And I don't see any difficulty in terms of incorporating another 10 member states. In 2004, there were 10 new member states from Eastern Europe. It did require some changes, but it just, in many cases, just involved extra chairs around the table,
And speaking of the different legal traditions and perspectives from member states, I know Ireland has a very proud tradition of judicial independence, and we also have consistently high scores for judicial trust and trust in the legal system, I think, more generally. We also now have Michael McGrath as the new Commissioner for Democracy, Justice and the Rule of Law as his portfolio. And I was wondering, from your perspective as a legal practitioner in Ireland and also as a judge, an Irish judge on the Court of Justice, can you think of any lessons that he can take from Ireland when setting out on his agenda for improving the rule of law across Europe?
Well, I'm not sure I would propose to advise Commissioner McGrath, but I do think that, as you mentioned, we have the constitutional tradition. We have an interesting legal system where we embodied Irish case law, old British statutes that remained on the statute books. We had in our court hearings and judgments references to English case law, to American case law. So it is a complex legal system. But the constitutional tradition and the fact that we are used to judges ensuring no arbitrary action by government, by equality before the law, I think that is the tradition that I bring to this court, and I'm sure that Commissioner McGrath would bring with him when he is fulfilling his role as Commissioner for Justice.
Thank you. Another interesting aspect, and perhaps it's unique in this, is the way in which the Court of Justice interacts with national courts through the Article 267 procedure. It's often called a dialogue between judiciary. It's also been described by the president of the CJEU as the EU's help desk, in that national courts can bring forward a reference to yourselves at the Court of Justice. You can apply EU law and answer the question. Do you think, however, in this dialogue where there is occasionally critique or maybe sometimes commentary from national courts that their legal system would come before the EU legal system. Do you think that poses a threat to the primacy of EU law, or how do you see that as a continuing dialogue?
Well, there is a situation of you have national constitutions, and of course, constitutional courts are responsible for interpretation of national constitutions. Our remit is the EU treaty as type of constitution. So there can be an issue of what's called national identity, that there is a particular aspect of national identity reflected in national constitutions, which should be respected. That is recognized in the treaty, that national identities would be respected. And there is various issues arise where that can be used as a means or a suggested means of not respecting EU law. So it is at that boundary that we often have cases, and of course we have a dialogue with national constitutional courts, and generally they are resolved in a manner which does not give rise to conflict. There was conflict in the case of Poland, but that was due to particular factors in Poland, but again, an issue that has been resolved. But there is that element of national identity, which is sometimes comes into play and comes up for discussion, but nothing that has raised, except in very isolated cases, any fundamental issues.
Another important aspect of the rule of law is the promotion and protection of a human rights culture. It's this alongside an independent judiciary and alongside the need for general, clear, non-arbitrary rules. Protecting human rights can often be achieved by a top-down approach where courts pronounce on human rights issues, but also through bottom-up or grassroots initiatives. In your experience as a lawyer and a judge, do you see other ways that civic European society can protect and promote this culture of human rights?
Well, again, I think the Irish tradition and the Irish experience in this regard is very instructive, because, we're used to constitutional challenges to various legislation or decisions. We're used to challenges to public bodies and the decisions they make. So I think there is a great awareness of fundamental rights, the rights of the individual, the importance of countering arbitrary power, arbitrary decisions. We're familiar with the European Court of Human Rights, going back to cases like the Norris case. So I think that it's a two-way thing. I think individuals are very conscious in the constitutional legal framework that we have in Ireland. And I think that by courts taking seriously issues of fundamental rights and having judgments which relate to people and their concerns, I think it's a two-way process, and all the court can do, it's not really an initiator of actions. It responds to cases that come before it. And I think it's the same in this court as in the court in Strasbourg in terms of the Court of Human Rights.
Again, casting an eye to the future of Europe, not only do we hold the prospect of an enlarged EU, but one where digital technologies, including AI, are likely to touch on the decision-making processes of the judiciary, as well as the administration of justice. Do you see these developments as challenges or opportunities for the rule of law? I know recently Commissioner McGrath spoke about the development of smart courts in the EU, and I was wondering if you have perspectives from your own experiences of working in the court or ideas for the future as to how these developments could be harnessed?
Well, AI poses a lot of challenges for society, but there are also opportunities for society with AI in terms of improvements in whether it's in medicine, whether it's various other areas. But in terms of, for example, this court, the AI in terms of simply translation, in terms of quicker, more speedy judgments, translation interpretation accounts for a lot of the delay in our decisions. I would see an opportunity there where if translations can be very accurate and more rapidly available, then we would be giving our responses to judgments and questions asked by national courts much more, more quickly. And I think that would be a very positive development. So I see there just specific opportunity. I think, again, however, there is an issue of confidentiality in terms of once issues are disclosed and the availability of that information and how it can be used. But I think that's one example of where I think AI could be actually of much use to this court.
Excellent. Thank you so much, Judge. I think this has been a really interesting conversation for me. We've been able to touch upon such a variety of topics, your own experience as a judge, some of the seminal cases relating to rule of law emanating from the European Court of Justice, looking as well to the future, whether that be enlargement, whether that be AI. I really want to say thank you so much for sharing your wisdom with us, and I hope to speak to you again soon. Thank you so much.
Delighted to oblige.
This podcast is brought to you by the IIEA, sharing ideas, shaping policy.